to today's webinar. Before I introduce today's speaker, a few house cleaning items. If you would like a certificate of participation to submit for continuing education credits, please email sales@bestnotes.com. Also, please mark your calendars for June 14th at 1 p.m. Eastern, when we'll hear from legal expert Nicole Wemhoff, who will be addressing recent changes to CFR 42 Part 2.
Oh, gosh.
Now, it's my pleasure to introduce Dr. Clifton Mitchell, who is an international speaker and clinical trainer with over 30 years of experience. His books include Effective Techniques for Dealing with Highly Resistant Clients and Priming, Programming the Mind for Habit Change and Success. Both are available on Amazon and audio versions.
No audio version. I should do it. I'm just too lazy.
I hear you there. If you have any questions for Dr. Mitchell, please enter them in the Q&A section below. Thanks for your time. Again, Dr. Mitchell, with especially being under the weather, we appreciate you being here. Please take it away.
Okay, well, thank you, John. Good afternoon. I'm Cliff Mitchell. It's not afternoon everywhere. I understand that right now. And let me get going right here. This is we'll call this Legal and Ethical Issues Review and Updates. And what I'm going to do today, and let me just mention, this is all copyrighted. It is ethics, so you can't go do your own training out of that sort of thing. But the purpose of what I want to do is review and provide some updates on legal and ethical issues with a few notes regarding the use of electronically submitted forms, the issue of when does the client become a client. I want to do some duty to warn stuff because there have been some recent cases there. So we're going to go over some basics, take a look at some questions that come up, and discuss all this. This is a special presentation. And by that, I mean, normally I do a full legal and ethical game show training where I have people in the audience and I ask them questions and they respond with notes. I put this together specifically for a 1-hour presentation for BestNotes. And I'm trying to cram a lot of stuff in here that I hope will be of benefit to you. Because of that, and because I am getting over COVID, I'm not pleased with my sequencing, but I think we'll get all the points in. Even though they may come at a little bit different times here. Now, let me make sure I've said everything I wanted to say there. If you have questions about any of this material, send them to John, our moderator, and he will look at them and read them and organize them and get back to me with them. And that way we can save time on answering questions that you have. All right. And with that, by the way, I will say I'm getting over COVID. I'm feeling very good physically. My only problem is my voice that concerns me. So if you can put up with just a touch of possible coughing, hacking, and me taking a sip every now and then, we'll get through this. So let's just take a look at, let me mention this. If you have a serious or longer legal and ethical dilemma or question that you want to talk about, there's my website. There's my email. You're welcome to write me. You can get my phone number there. Call me. Don't call the cell. Call the office phone. And I'll be glad to discuss whatever your issues are with you. You see, you get a consult. I don't mind doing this. People are very good about my time and on doing it. But I will not answer legal and ethical questions in email because you end up having to write a book and it's just not worth it. But you give me a call and then you'll regret it because I'll talk your head off about it. Okay, let's get going. So we're in mental health. We get our guidance from laws and codes, which most of the time are in sync, sometimes appear out of sync, but amazingly, we tend to manage it when the laws and codes don't appear to be so much in sync. Under the codes, we have the principal mandatory codes. Everybody knows that's the ethical codes most people keep in mind and think about. And we also have what's called the virtue aspirational codes, which are broader stroke philosophical issues and points from which we draw guidance. Okay, so we're going to take a look at where we stand on some of this stuff from these ideas, but let's just go over some basic here and talk about informed consent. Everybody knows you got to do informed consent with every client. So what do we got here? Informed consent is a reasonable disclosure of information necessary for the client to make an informed decision about entering or continuing counseling or speaking about certain topics in sessions. It's where we set down the rules of this relationship with the client. The client has a right to know the rules. They have a right to understand the rules, and then they must consent. Okay, I understand the rules. I consent. Let's continue with the session. So let's ask a very basic question about informed consent. I'm going to give you about 10 seconds to answer in your mind. True or false? Informed consent is a one-time event that occurs at the beginning of all counseling relationships. I actually have me a timer clock I'm going to be watching. Answer that in your mind. Make a note of it, a mental note or a written note. And let's take it to look at the answer to that. The answer is false because of two words in that question. And those two words were one time, which I'm sure most of you out there recognize. Informed consent is done at the beginning of all counseling sessions and anytime you need to bring up something about the rules of this relationship. You stop that client and you say, don't go any further. Let me tell you about the rules on that particular issue here. Then you say, come on. So informed consent is an ongoing process, but you do always do it at the beginning, but not only at the beginning, anytime you need to do it. Okay, what goes into an informed consent? Everybody knows this stuff. When the client's going to lose confidentiality, rights regarding seeing records, payments, consulting with colleagues, credentials, therapeutic approach, recording, no-show policies, all of that good stuff. So let's ask another question. True or false? Every instance where clients may lose confidentiality or privilege should be discussed in or before the first session. I'll give you another 10 seconds to think about that. Every instance. Well, the answer is again false. No, not every instance needs to be discussed. In fact, you wouldn't have time to do every instance. In another part of my legal and ethical game show, I list 8 other times beyond the main ones we talk about, I'm going to bring up in a minute, where people lose confidentiality beyond what I call the big 4: harm to self, harm to others, suicide, child abuse, elder abuse stuff. But I have a list of about 15 times beyond those basic ones. And I was in a training one time and I had an attorney that had said, I have 30 times beyond that. You don't have to do them all, but you do have to do certain ones. What do you need to do? Well, you should verbally and written always do what I call the big 4: child abuse, harm to self, harm to others, elder/handicap abuse. Now, I call this the big 4. That is not a formal term, but my students know that when we say the big 4, we know what we're talking about. It's like saying Tarasov. Everybody knows the case. So when I say the big 4, you know that I'm going to be talking about child abuse, harm to self, harm to others, elder or handicap abuse. And I call this the big 4. They should always be presented verbally and written in your informed consent. Quick note, somebody didn't like it one time that I used the word handicap. It wasn't the current politically correct word, but when these laws were written, the laws used the word handicap abuse. So that term I'm using because that's what is in the law. So you always want to discuss the big 4. Now, let's look at another question here. Let me mention, let me see where I am, make sure I'm on track here. Yeah, let's do a question here. There are 4 components or points of fact that must be in place or that must have occurred before informed consent can be deemed valid, binding, and or legal. How many can you name? What I want you to do is send this to the host. Just send him a word or two, and I'll be asking John in a second. Now, I'm not asking what goes into informed consent here. I'm asking what things have to be done, what things have to be in evidence, in fact, for your informed consent to be a valid, binding, legal informed consent. And there are 4 components that make this up. John, has anybody sent you anything yet?
Bit of a shy group
Take a
This
guess,
morning,
somebody,
definitely.
throw something out. You're better off guessing and being wrong than not. If you don't, I'll go over them, of course.
Vicky, I'll unmute you.
Or they can just type it into you. You got anything?
The chat is disabled, but my guess is that you have to review it verbally and have the client sign it and you sign it.
Okay. They have to, it doesn't have to be signed. Well, you do want to document it, and documenting is one of them. I'm not sure what you said about the first thing there. You do want to always review it verbally and have it in your written agreement. Let's go over them here right now. 4 components or points of fact that must be in place or have occurred before informed consent can be binding and or legal. First, the information must be understandable and comprehensible to the client. You can't use a lot of big 50-cent words. You can't give it in a language that they're not familiar with. If their native language is Spanish and they do not know English very well, and you do an informed consent in English, it's not valid, legal, and binding because they didn't understand it. I used to serve, excuse me, on my university committee that reviewed research. And at my university, we had a medical school, and it was the medical school research that we were really worried about because these doctors were testing drugs on people. And these doctors would come into the committee and show us the research they wanted to do and show us their informed consent. Boy, this committee used to jump them because they would always write their informed consent with these big 50-cent medical terms. And the committee would look at the doctor and say, you go back and write this so a high school graduate can understand it. Don't say hemoglobin, say blood. And we would run through it and get kind of firm with them. You can't be talking a lot of medical ease here. You can't be talking a lot of legal ease or mental health ease. It's got to be understandable language, which is not hard to do. The second issue is the client must be competent. They can't be drunk. They can't be floridly psychotic. They can't be out of it. They must be aware of what's going on and competent at the time that they agree to the informed consent. And if they're not competent, they're on drugs or psychotic or drunk or something, it's not valid. The third is it must be voluntary. You cannot coerce an informed consent. Listen to the word consent. They're informed, then their consent. If you're coercing it or putting pressure on somebody to do it, it's not consent. It invalidates it. And the third, which you just brought up, it must be documented. Now, you don't necessarily have to sign it yourself, but you want them to sign something that shows that they got the informed consent and they've agreed to it. I'll make a point here. If you go online and you look at some of these online ethics courses, and this question comes up rather frequently, except they only list 3 things, the first 3. Well, if you don't have number 4, you cannot substantiate the first 3. So you need all 4 of these to be in place before informed consent is deemed valid, legal, and binding. So that's a little informed consent review, but I'm going to come back to informed consent, but I'm going to leave it for a moment and talk about a question that pops up not infrequently in my trainings, which a lot of people never get a very clear answer on. And I'm going to give you the clearest answer I can get. And that is, when does the client legally become your client? And that's not a very hard question to answer. I'll give it to you as best I can. Client becomes a client when the client takes action to request or require your assistance, and you take action that demonstrates agreement or you concur or acquiesce with the request. So the client calls you up, says, I have a problem, I want to talk to somebody. You say, fine. I've got an appointment next Thursday at 2 o'clock. They said, good, I want to take it. Okay, you take it, boom, they're your client. What happened? The client requested assistance and you took action that acquiesced with that request. Now, at this point, your liability, your obligation to this client is very minimal, minuscule. It doesn't hardly exist other than the fact that it's the embryonic stage of this relationship. This is the legal point of beginning of the relationship. Even if they're involuntary client or court ordered, when they come in there, you're going to have to still do an informed consent, and the client's got to agree. So the client has to have some level of agreement with the relationship. So let me tell you what it's not. You did not become a client at the point they enter your office. They become a client at the point they agree to make an appointment, or when they pay, because some people don't pay, but you're still obligated, or when insurance agrees to pay, no, or when you feel they need help. Just because you see someone that's hurting or depressed or grieving, and you say, look, you're really hurting over this situation. Here's my card. I really think you need to see someone and talk to them about it. Are they a client? No, not because even if we think they need help, they're not a client. They become a client when they say, look, it's a good idea. May I make an appointment with you? Yeah, call me Monday morning. They call Monday morning, make an appointment. Now they're a client. But you have very, very little legal or ethical obligation here. So the embryonic point is when the client really recognizes you as someone they're going to go to for help, and you do any action that says, okay, come on. So what happens to your obligation when you send out an electronic or otherwise intake form to be completed? They haven't come in your office, but in this world of internet and email, everybody's sending mailing forms and emailing forms to fill out this information. Well, nothing much additionally has happened other than you have further acquiesced to the notion, this is my client. So the client therapist relationship is legally more established, but nothing much has happened. Okay, so they fill out some intake form, depending on how it's written and how detailed it is or what it's asking. And then it comes back to your office. What happens when you receive an electronic or otherwise intake form in your office? Well, lots of things, depending on what they say on that form. Depending on how detailed it is, its name, address, and phone number, and where you can be reached, there's probably a little bit of information. But if it's a type of intake form that starts saying, what is your problem? How long have you had this problem? What's your family history? Blah, 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 blah. Have you seen somebody in the past? And you start going into details. What happens if they start telling you about one of the big four? Wow, now you have some serious obligations. Even though you haven't seen them in their office, they're your client, and they've given you this information. You've got to respond to it. Now, let me make sure I'm on track before I go here. So when an intake form comes back into your office, it needs to be reviewed really quickly, because telling you what the client said, and depending on what they said, you could have obligations. Well, you say, well, suppose we say in our office, we don't consider the client a client till we've talked to him face to face. So you're declaring you're not a client until we see you face to face. Can you do this? Can you relinquish your mandated legal and ethical obligations, is what you're asking. And the answer to that, I'll tell you, short answer is no, you can't get out of it. You're in mental health. There's no law or anything anywhere that lets you contract out of the obligations you have to break confidentiality when required to do it. So even if you were to say, hey, we haven't really accepted you as a client, you can't get out of your obligations that are mandated by law. So you've got to do something when this stuff comes back into your office there. Now, so no, don't try it. You can't contract out. Now, there are issues that you can contract around. Appointment times, how somebody is going to pay, what service you provide or don't provide, how you missed appointments, obligations on missed appointments, payments on missed appointments, what type of problems you'll see and won't see, when you might refer out to someone else who's better at a certain problem than you. So there's things you can contract around and things you can't contract around. You cannot contract around your legal and ethical obligations. I also might mention you don't try to contract out of sex with clients. It won't work. You think, well, I'll sign a contract and have sex with my client. No, you're still legally obligated. You can't contract around lots of things there. All right, where am I going here next? So this whole thing goes back to when does the client become a client? And legally, it's when there's some acquiescence on your problem. They ask for problems. So they send it back. Suppose they say they're suicidal. Wow, you've got to act, and you need to act quickly. You can't tell, this person says I'm suicidal, and you've set an appointment out for 2 weeks. Suppose they kill themselves in that 2 weeks period. You haven't taken any action, warned anybody, tried to save their life. You're going to be liable. And you need to be aware of this. Suppose they're homicidal. Whoa, even worse in this, mass shooting, gun-toting society we have right now. And I'm going to talk about this more in a little bit because there have been some recent duty to warn cases that are shifting our obligations. It looks like it's a trend. I'm not sure where it's going to go. But if somebody sends back one of these forms and they're telling you I feel like shooting people, you've got some strong obligations. You need to act and act quickly. And you say, how quickly? Well, the state of Tennessee, for reporting child abuse, our law says immediately. It doesn't even give you a 24-hour waiting period. Some states give a 24-hour waiting period. I don't think I've ever seen one beyond 24 hours. So on the serious issues like the big four, there aren't large time spans allowed by the law. Most of the laws say you've got to act and act quickly on these things, even though the client hasn't come into your office. So what does this tell us? Well, the first thing I'm going to say is informed consent again. Informed consent is not only informing the client of the rules of the relationship with the therapist. Informed consent is also our first defense against tort law or lawsuits. When you do informed consent, you're laying down the rules and you're putting up a barrier to the client suing you if you do certain things because they've agreed and understand it's there. So you should have informed consent on your intake forms that you send out, particularly if they go into more information besides name, address, telephone number, sort of information. It should be right at the top. Client should see it and know if you tell me these things, I'm going to break confidentiality. What if you leave it off? Suppose you send out an intake form that asks a lot of detailed questions about the client and their world and their problems. And it didn't say anything about informed consent on the form. You just left it off. Well, I don't want to let them know this. Does that mean you don't have the obligation? No. You just made two mistakes. Actually, you just made one mistake. You didn't do informed consent. But just because you didn't do it doesn't mean you don't have the obligations. I've literally seen cases where this happened. Usually a school counselor calls me. Says, I had a student rush in my office and told me this, what do I do? And I said, you did informed consent, and the phone goes blank. I go, you didn't do informed consent. Well, we were in a hurry. Well, now you got to go back and do informed consent. But just because you didn't do informed consent does not mean you do not have the legal obligations you have. You just forgot to tell the client you have them. Now you've got to straighten that out and follow through with your legal obligations, what to do. The client has a right to know this. So you don't want to leave it off of electronically transferred or paper type of intake forms that you may send off in the mail. So what are the implications of all of this? Well, let's just summarize what I've said over and over. One, your electronically submitted intake form should have at a minimum an informed consent statement on it at the beginning that the client signs and lets them know their rights, and you get their agreement right off. Okay, if you're going to ask detailed information, you need to have an informed consent block on there that they agree to, knowing that if they know they're going to tell you things, you're going to break confidentiality. And of course, this needs to be in understandable language. In other words, language that a high school graduate could understand. There's nothing legally that requires it to be fancy legal terms. Two, your business needs to have a person or their proxy who immediately reviews intakes forms when they arrive at your office. And again, I'm talking about intake forms that may start inquiring about details about a person's problems, where they may directly or indirectly start telling you information about child abuse or harm to others or suicide or elder abuse or some of this big four stuff where we are required to act. I'm going to push a button here, try to get rid of this hide. Where's my hide floating meeting controls? There we go. Get rid of that. Now, 3, you need to get a confirmed contact information from a client that you send these forms out to. You need to make sure that that telephone number is their telephone number, their address is their address, they are who they are. Because if they send you one of these forms back and they're telling you serious stuff, you've got to be able to contact them. And the last thing is, of course, when the client comes into your office, you need to once again repeat your informed consent process. Why? Because you need to assess for competence. You really can't assess for competence if you have a written informed consent that went out to the client. You can if they come to your office to some degree. So you just because you did an informed consent through the mail or through electronic form does not mean you shouldn't repeat it when they come to your office. And let me leave this topic for now, but I'm going to make another little question point here. Ethically, who is the client? And I want to make the point that the client is the person ethically sitting in front of you who you're talking to. So if the parents send the child to you for counseling and you're counseling with the child and the parents aren't in the room, the child is the client. The ethical rights go to that person sitting in front of you. It's not the insurance company, not the parents, not the school, not who's paying. Ethically, the rights go to the client. Now, real quick point, I don't have time to go into detail about. Day in and day out, mental health professionals are great at managing this. Down to age 14, you should treat 14 and above just like they were adult in your office and they own the rights. 12 to 14 is kind of the no man's land. Below 12-year-old is where you start working with the parents and the kids, and you don't keep confidentiality as much. The younger a child goes, the more you talk with the parents about the issues they're dealing with, and mental health professionals manage this really well. However, teenagers in your office should be treated like they have the rights, they're the client, just like an adult. Now, let's see, John, are there any questions about any of the material I just went over, or any of the ideas?
Couple of questions. Is there any liability when you discharge a client while he or she is experiencing SI?
Experiencing what?
SI. I was trying to get clarification on that.
I'm good. What is SI? What are you referring to?
Suicidal ideation.
You said what?
Suicidal ideation.
Are we talking about suicidal ideation?
Let's take that.
Yeah, I would think so. I wouldn't be discharging a client with suicidal ideation unless I'd taken some further actions on this. Because, and you know, if put it this way, when a client tells you they're suicidal or having suicidal ideations, they've, as far as I'm concerned, lost confidentiality. You can tell anybody whom in good faith you think can help save that person's life. Now, the mistake mental health professionals make is clients come in and they dangle this suicide in front of you. I'm thinking about doing, but I might not do it. I'm just thinking about it. I don't know if I'm going to do it or not. And you're sitting there trying to sort through whether you need to take action or not. When this happens, you need to take action and show this client, I am very serious if you start talking about suicide with me. For why? Well, because sometimes these people dangle it, you may discharge them and they go kill themselves, and somebody finds out that they talked to you about suicide and you took no further action. Now they want to sue you. And how do you manage this? The other reason is it's cover your butt. You know, hey, I told you in the informed consent, if you start talking suicide, you lose confidentiality. So you're going to tell the husband, the wife, the dorm director, the family. In fact, if someone starts talking suicide, one of the first things I think mental health professionals should do is say, okay, I want the names of contacts and people around you that I can contact if you have me so worried about you that I want to inform others around you. You need to start building up this protection with these clients. I had a local 2-year college bring me in and was consulting. They have tons of, not tons, but a fair number, excuse me, of students that do have some type of mental problems there. And a lot of them start dangling suicide in front of their teachers and the counselors. And my answer to them was, don't fool around with this. They've lost confidentiality. Call their parents, call their husband or their wife, call anyone whom you think can help save that person's life. The worst thing to do is do too little than too much. It also sends a message to the client. I am very serious if you start talking suicide that I'm going to break confidentiality and report it to other people and try to do something to help you save your life. So I would not be discharging a client that has serious suicidal ideations without at least telling some people around that client, this is what's going on. And you, of course, want to give them referral sources, which all you have to do is hand them a piece of paper. Here's some other therapists and places you might go for help. And when you do that, you've done your job on that. You haven't abandoned them. I hope that's a decent enough answer for you there. Anything else coming in?
Should you inform the potential client about the potential limits of confidentiality due to the Big Four?
I'm not sure what you're saying. The potential limits of confidentiality, meaning the limits are the Big Four. You tell me about child abuse, you've lost it. You've reached the limit. You tell me you're suicidal, you've lost it. You've reached the limit. You tell me you're homicidal, you've lost it. You've reached the limit. You tell me about elder abuse or handicapped abuse, depending on how the laws are written in your state, you've reached the limit. You've lost it. And there's actually many other times potentially, but that's a real too complicated for today. So I'm not, is that what they're asking in the question there? I'm not sure what they're asking.
Yeah, my assumption is like when you're talking about like child abuse, like where is the gray area of that? Like, oh, I heard.
Let me tell you my answer to that.
Yeah.
Someone comes in and starts talking about a child that's potentially being abused. Now, virtually every law in the states that I've read says something like, when the therapist or whoever has to report reasonably suspect this could be child abuse, you have an obligation to report. The problem is so many laws say reasonably suspect or a reasonable adult. So I tell people this, you have a meter and this person starts talking about what's going on in my meter, starts clicking up and clicking up. When my meter gets to the point in my brain, that little voice says, you know, this looks like it could be child abuse. I have reached the point where I am reasonably suspecting it could be child abuse and have a legal obligation to report. And I think we all have that meter. If you're going home at night and you're laying in the bed and that little voice in your head says, God, this sounds bad, this sounds like, then you've probably reached the legal point, because the point is legally is when you reasonably suspect. It's not when you absolutely know. It's when you think it could be reasonably from the information you have. So the standard gives you some freedom. And usually that little voice in the back of your head will tell you where it is. So when my meter gets up there, boom, I do it. I've had my students who would be on an internship come in and report to me. This is what the child's reporting, or This is what someone's reporting about a child. And I say, what do you think? Well, I say, I don't know. It's hard to tell. Is this just a parent disciplining their child, or is it more? And I go, yeah, I'm not quite there yet. Go back and talk with us some more and come back, report back. And they'll go and talk more and they'll come back. And I said, where's your meter now? And they said, okay, I had a conversation. I think this looks like it could be child abuse. My meter hit the point. I hear that voice in my head. Okay, now you have a right to report. So that's the best answer I can give you based on the way the laws are written there. And the client has every right to know what you're going to do, by the way. Here's what I'm going to do. I'm going to call Department of Children's Services, or whatever they call it, Family Services, whatever they call it in your state. I'm going to have to report this to them. I'm legally obligated. And by the way, I say you should always have a copy of these laws in your desk that you can pull it out, sit it down with the client, read that fine print, no pictures, and say, here's the law, hand them a copy so they don't have any issue about why you have to do it and what's going on. Same thing with duty to warn laws, handicap abuse reporting laws, all that stuff. Have a copy in your desk, pull it out, run over with the client. It certainly does smooth out them understanding your obligations. Any other questions there?
Yeah, should a treatment plan be discussed with the parents of a 14 through 17-year-old?
I personally would say no, depending on the situation.
How much information?
Okay,
would you
let me
disclose?
tell you, this is, okay, first thing, this is the grayest of gray areas in the field of mental health. How much right do the parents have to what a child says in a counseling session, someone below 18? Now, I don't have time to go into this in great detail today. However, go to my website, cleverly named CliftonMitchell.com. Go to the tab called Articles, go under the ethical articles, and there's an article called When Parents Want to Know, Responding to Parental Demands for Information. I forgot even the title of it, Responding to Parental Demands for Confidential Information of Children, or whatever. This article is the only article I know that's been written on this and discusses all the angles and the issues and whatsoever about it. And when you finally get through all the technical legal stuff, if you're not asleep, when you get to the end, it's going to give you a list of suggestions for managing this. Now, let me say this about this. Day in and day out, mental health professionals are great at managing this. How do I know this? Because there's no lawsuits. There's no therapists getting sued for not telling parents what their teenagers are doing. There's just no lawsuits about this. There's no cases. But we do manage it, and you have to manage it. So let me say this about it, trying to do this quickly. Technically, legally, parents own their rights of their minor children, except for the places that states have taken those rights away. However, ethically, the rights go to the client. And who is the client? The person sitting in front of you. So we have a conflict here, but we manage it well. Let me give you another piece of information. Developmentally speaking, 14-year-olds and above are developmentally able to understand the concepts of informed consent, confidentiality, privilege, breaking it, and grasp all of that. 12 to 14 is the no man's land. Below 12, they really aren't old enough to grasp the meaning of all those concepts. Some people have argued that 14-year-olds and above for this reason should be treated as adults. Day in and day out, I say ethically, you treat the 14-year-old and above as an adult. Nobody's gotten in trouble for this, but we have to manage it. How do you manage it? When you take on a teenager or a young child as a client, you set the child and the parents down, and you establish the parameters and the rules from the beginning. You look at the parents and say, I am not here to be a tattletale to what your child is doing. I'm not the sex police. I'm not the marijuana police. I'm not the drinking and drug police. Don't be asking me to be a go-between to find out what your child is doing. Then you look at the teenager or whatever, and you say, but listen here, I'm going to tell you something. You start telling me about harm to yourself or some serious harm or suicide or harming others and things, and I'm going to break confidentiality. really fast. And so there are limits to what you can tell me. Now the question arises, how much drug abuse or alcoholism or stuff do you hear before you break confidentiality? Now, I don't have a clear answer to this, but I did a training one time and a lady said, here's my answer to that. She tells the teenager, I don't tell your parents about your drug use or drinking or whatever, unless I see signs of addiction. And if I see signs of addiction, I'm considering that harm to self on your part, and I'm reserving the right to break confidentiality. I have my limits. If I see reckless behavior on your part, maybe street racing while you're out drunk or something like this, that I think you could harm yourself, I'm reserving the right to break confidentiality. If you have cutters, self-injurious behavior, you don't break confidentiality beyond that, but you never assure it. You tell them, if I see you cutting too deep, if I see what looks like infections, that you could seriously harm yourself, I'm reserving the right to break confidentiality. So you set limits and you get this straight with everybody from the get-go. And we manage it day in and day out. We do a great job. We do a great job. I know, because there's no lawsuits and cases. Most of the time parents understand and they're fine and they're willing to get along. How's that for a long-winded answer to a complicated question? Go read my article. Particularly if you ever have insomnia, it would be great for that. It'll put you right to sleep. But if you get through it, there's a whole list of ideas for managing confidentiality between kids and parents. And we do, you'll see what it does, and we get through it. How's that? Any other questions?
We have a treatment center where it may take days or weeks to actually admit a client. For example, they're applying for a single case agreement with their payer. Many have PTSD and suicidal ideation. What do we do?
Excellent question. First thing, you should have a legal team or somebody here who understands the implications of what's happening if you're delaying that. It's the same thing I just talked about. So the client comes in and says right off, I'm suicidal. You've got a 2 or 3 week delay and they kill themselves. The family says they went for help. By the way, when the client dies, the rights of those records go to the heirs of that client, just like everything else goes to the heirs. So the heirs of the client would have the right to see the records legally. They see the records and see the client reported to you they were suicidal and you took no immediate action on that. They could, probably have a very good lawsuit here. And people need to be aware of this. And so fortunately, we manage this, but we get lucky. And sometimes people commit suicide and there's nothing we can do, and we don't get sued. But suicide is probably in the top 5 reasons for the high-paying lawsuits out there, is a failure to respond to suicide. So I just think your clinic needs to, be fully aware. I know if I worked there and a client came to me like this and I knew this, I would make sure I told my supervisors repeatedly if necessary, there's a legal and ethical danger here. Put it in the notes you told the supervisor. The more people you bring in on something, the better off you are in dealing with it. I understand it happens in mental health all the time. Don't have a clear answer for you other than be aware of the danger. You might set up a system of regularly checking on that person until you can get them in the clinic. In other words, you could have someone call every day or every other day and double check, say, we want to get you in. We want to see how you're doing. We want you to know we haven't forgotten about you. Something like that may aid and help in this situation. Best I got for you.
Another one here. under the age of 12, when we get back to this idea between confidentiality between a child and a parent, if the child's 12 and under, is the confidentiality boundary?
It's not gone, but pretty much the younger children are, the more we talk to parents about what's going on and what they're talking about. When you're seeing 12 and unders, what are you seeing? Maybe a child was abused. Parents probably already know it. Parents are divorced and the child's really upset, going through some childhood depression. Generally talk with parents about how they're coming along and how they're doing. It's okay. People do it. They're doing it in good faith, not out of malice. They're doing it because it's as aid to help. No one's ever gotten sued for breaking confidentiality with parents on a 12 and under or child acting in good faith. It just doesn't happen. And we're very good at managing that. The place where you run into trouble is more of the older teenager who has those rights. The courts legally are extending rights downward and giving them to teenagers as opposed to taking them away, by the way, as a general trend. So 12 and under, yeah, you can tell the parents how they come. You may have a group at school for kids that are children of divorced parents, and maybe a group of kids who've been abused, you know, but you can talk to parents on how they're doing, how they're coming along, what's going on. It's not an issue. We manage it well.
Last question. In your professional opinion, Dr. Mitchell, in this day and age we live in, would you recommend that a clinician adds cyber liability coverage to their professional liability coverage?
I'm not sure what cyber liability coverage is. Are you saying you're doing counseling and therapy over the internet or on Zoom or face-to-face?
Yeah, I would think it's the big umbrella of like all things internet, email.
Okay, now let's talk about this a bit. I don't know why, and do not know the details now, been out of the business long enough, why there's separate liability for therapy done over the internet than therapy done face-to-face. I would think that any therapist policy these days should include Zoom, FaceTime therapy, and that sort of thing in the policy. If it doesn't, I would kind of question it because there's so much of it going on, and the research says it's working, by the way. 90+% of the clients are fine and satisfied, and are improving. It's working. Now, when you start talking about email, I have some very firm policies. You don't do therapy with email, period. Email is for our appointments Thursday at 2 o'clock. See you then, fine. We'll connect then, fine. Don't be doing therapeutic talk with email. And the reason is there's no paralanguage. Clients can misconstrue what you say. Everything you say can be used against you if there's a libel case. If they misconstrue what you say, the buck still stops with you, not with them. You just don't want to get into doing that stuff. It's a trap. And clients misconstrue enough of what we say without confusing it worse with email. There's no paralanguage. There's no expression. Listen to this statement. I did not say he hit his wife. 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 If I accent a different word of that statement, I change the meaning. So you send an email to someone with a statement like that, you're accenting one word in your mind, they're accenting another word in their mind, they completely misconstrue it. So everybody puts smiley faces and emojis and everything trying to get the emotion in there. Email is not a good medium for doing therapy because there's no paralanguage. Do it FaceTime, face-to-face, and over the internet, and it is working. So you need to become very aware you're setting yourself up for problems trying to email therapeutic dialogue. Now, there's this whole thing of social media. I don't have time to go over it. I've got a whole section in my new game show. You don't become any type of social media friends, whatever platform you're using with your clients, period. You stay away from it. And the social workers, the counselors, the rehabilitation counselors, the drug and alcohol counselors all have rules in their ethical codes on even going into the internet and searching the client and looking at them. You need to go review your ethical codes on what it says. The psychologists and the psychiatrists have yet to address this issue in their codes, but the others have addressed the issue and have got statements on whether you can even look at someone on the internet or ask permission to do it. All of them say don't be making friends with people through social media platforms. So you need to understand the rules that are out there in the code. You need to stay away from emailing therapeutic talk. It seems like to me that any worthy insurance is going to cover internet type of therapeutic situations. I don't understand why you'd need something else for cyber stuff. I mean, if your cyber communication should be considered just like a formerly paper communications. And you should be very careful what you're sending too. Everything's a record. Everything's out there. You can't take it back. I hope that's a worthy answer. You are welcome to call me, talk to me about this issue. Again, go to my website, cleverly named CliftonMitchell.com. Dial the home office number, shoot me an email. We'll set up a time to talk if you have some detailed questions on managing this. I hope that's given you somewhat of an answer of what you're asking.
Awesome.
Any
just
other
have,
questions?
5 minutes left here. We'll just spend the rest of the time with questions, if that's okay, Dr.
That's
Mitchell.
fine by me. Whatever they need, I'm good.
Donna, you have your hand up. I'm going to unmute you. Feel free to ask your question.
I think you did. I had asked the question about under the age of 12, because so many of these kids are so young, but I think he already answered it, but
Yeah.
thank you.
You're fine sharing basic information and information with parents under the age of 12. It's just, let me tell you, it's a very gray area that we manage superbly, but we need to be aware and manage it. But under 12 kids, therapists talk to parents how they're doing. Yeah, they're talking about this and that. It's fine. You don't give excessive information, but anything, the general gist of what's going on, it's fine.
Thank you.
Thank you for the question, Donna. Just to go a little bit deeper into age, there's a question that came up. You were referencing treating 14-plus-year-olds as quote unquote client.
Oh yeah, they're the client. If they're the one sitting in the room.
And I think the question is like, where did that come from? Is that a state specific thing? Is it illegal? Is it an ethical thing or both?
It's ethical.
Ethical.
And it's complicated as it can be. And I'm not trying to force an article on you. If you go read that article, when parents want to know, what it basically does, it runs through initially the writings and the codes and the statements that have been made regarding this. The rights go to the client. The client's the person sitting in front of you talking to you. The codes don't say the client is the insurance company or the parent if the child's sitting in front of you. The parents don't have the confidentiality. The child has the confidentiality. There's even a comment somewhere in the article that says the Supreme Court actually ruled that rights of privacy extended down to below 18-year-olds in the Constitution. And don't ask me the details on that. It's somewhere in the article, which I haven't looked at in years. So this is the ethical perspective. See, so listen to this very carefully and listen to my wording. Technically, legally, parents own the rights of their minor children, except in the places that states have legally taken away their rights. Where is that? Well, a minor can go get treatment for an STD without parental permission. Now, in the state of Tennessee, and I don't know where all this is with all this abortion stuff, but a 13-year-old or younger could even go and get a morning after pill in the past from the health department. So there are certain, a minor can go get treatment for drug and alcohol addiction without parental permission in many states, like Virginia for one. Now, why do they allow this? Because they say, look, if a child with the STD had to get permission from the parent to go to the doctor and get treated, they probably wouldn't even do it, and they would just be spreading STDs and get worse themselves. So we're going to take away the parental right and give it to the minor child so they can get treated. Technically, legally, parents own the other rights. However, ethically, the rights go to the person sitting in front of you. So we have a conflict in the law, and it even gets further complicated. In the state of Tennessee, where I live, a 16-year-old has the right to enter into a contract, like buy a car, and the rights that come with that contract. So a 16-year-old comes into your office, and you establish a contractual relationship with them, between them and the therapist. There is contract law that protects their rights, which is in direct conflict with these other laws. Now, the other laws of parents owning the rights of their minor children are generally just kind of historical assumptions over the years. The good news again is, though, we manage it. We manage it because it's not clear anywhere. But we explain to parents, you know, I'm not here to be a tattletale. And most parents get it. They say, I know enough already. Fine, you deal with it, you know. So but we couldn't run the counseling session with, say, a 16 or 17-year-old if every time the parent wanted to know what they said, you had to tell them. They wouldn't come to counseling. Think about it. So it would destroy the relationship. So from the ethical perspective, no, we're going to put these rights, and we're going to give these rights to the person sitting in front of you, with some understandings of when you're not going to break confidentiality. Does that make sense? I ramble around. You say one thing another, and they sound like they're contradiction, and they are to some degree. But like I say, we manage it. We do a great job. We do a fantastic job. Try to find a lawsuit. Try to find a case where a therapist has been sued for not revealing to the parent what their 15-year-old, 16-year-old, 14-year-old said or something. It doesn't exist. You know, and if you took it to court, I don't know what a judge would say. Judge may say, no, if this 14-year-old thinks they need therapy and won't, and the parents are too dumb to realize it, I'm going to give the rights to the 14-year-old. Get out, stay out of their life. That's probably why they're so messed up to start with, or something, you know. So it's sometimes it's the lesser of two evils. Do you take the right away from the parent and give it to the teenager, so the teenager will have an adult that they can talk to honestly and seriously about their life? Think about this. If you took away the confidentiality of a teenager, and they knew everything you said that you would have to tell their parents, so their parents could find out, would they ever come to you? And the answer is no. So the state of Tennessee mandates that we have counselors in the schools. They're in essence mandating that this teenager should have an adult they can go talk to with confidentiality about the things going on in their life. And because they realize, if I take that away, now this teenager doesn't seem to have any adult they can go talk to, which is worse. So when you really look at it, this is why I think it's why you don't see any cases or anything about it. Does that make sense? Practically, you have to give the rights to the teenager sitting there until things get seriously dangerous in some way.
Unfortunately, we are out of time. Dr. Mitchell, thank you so much for your time today and all this great knowledge and great questions.
Let me make a closing comment or two. First thing, I hope there was something in here of benefit to the people out there today. Pardon me for my little bit of hacking and coughing. I'm doing pretty good relative to the way I've been feeling the few days ago. Today, I feel real good. If you have a question about some legal and ethical concern, again, you're welcome to contact me. I don't answer them with email, but we can set up a time, we can talk, and I'll run through the yins and yangs and issues and give you my best guess at an answer for anything you have there. So I'm available for you if you need me, and I'm pretty easy to reach. I'm retired, so I'm sitting around the house working on my various projects, but we can talk. So I'm not leaving you out there if something's still vague. I can create more vagueness too, by the way.
Thank you so much, Dr. Mitchell, and thank you everyone for being here today. See you next time.
Thank you.
Cheers.